Good afternoon. My name is Neil Siegel, and together with Chris Schrader, I direct the program in public law here at Duke Law School. This year, the program in public law and the Duke Journal of Constitutional Law and Public Policy are sponsoring a Lessons Learned lecture series. We have invited some of the most respected legal scholars from around the country to reflect on the Bush administration's engagement with various areas of law over the last 8 years, and to inquire whether there is any wisdom to be gleaned from the experience that the next administration might bear in mind. The subject of today's lecture is the Bush administration and international law. And on this topic, we decided that we need look no further than Duke's own Curtis Bradley. Curt Bradley is the Horvitz Professor of Law and Professor of Public Policy Studies. He is also currently the Senior Associate Dean for Academic Affairs, in which capacity he has devoted an extraordinary amount of time and skill to advancing the institutional mission of the law school. Professor Bradley graduated magna cum laude from Harvard Law School in 1988. He then clerked for Judge David E. Bell of the United States Court of Appeals for the 10th Circuit, and then Justice Byron White of the Supreme Court of the United States. After his clerkships, he practiced law in Washington, D.C. for several years, and then spent roughly a decade in the legal academy. In 2004, he served as counselor on international law in the Legal Advisor's Office of the United States Department of State, and in 2005, he joined the Duke Law faculty. He's now a member of the Secretary of State's Advisory Committee on International Law, Executive Council, and is on the board of editors of the American Journal of International Law. He has written many law review articles concerning both international law and U.S. foreign relations law. He's also the editor, with Duke's own Chris Schrader, of Presidential Power Stories, a 2008 volume, and Curt is as well the co-author of two case books, one on foreign relations law and the other on international law. He's currently working on a book concerning international law in the U.S. legal system, which will be published by Oxford University Press. Please join me in welcoming Professor Bradley, and Curt, may it always feel this awkward to welcome you to Duke.
Thanks, Neil, for the introduction, and thanks, everyone, for coming. So I was asked to prepare a talk about the Bush administration and international law, and my immediate thought was, wow, this is going to be a really short talk, and no such luck. However, I reflected a little further. But the initial impression comes from, I think, what many of us would understand as the standard view of this topic and maybe the lessons from it, which is the standard view you hear in the media and I think a lot in the legal academy is that the Bush administration quite clearly has not taken international law seriously as law, and as a result has routinely disregarded it whenever it has been perceived not to be in U.S. interests, and usually the critics would contend narrowly conceived U.S. interests. And as a result, the administration in its time in office has substantially undermined the international rule of law and the United States standing in the international community. And one of the priorities of the incoming Obama administration should be to recommit the United States to international law and institutions. And I think that hopefully sounds familiar. That's certainly the criticism I've seen a lot. And it's not to say there isn't anything to it, but I do want to unpack that a little bit in my talk. Critics have a wide variety of examples they would cite to support this standard view, and I think it might be useful partly just to remind us of some events that have happened during the administration that do connect up with international law, to go through some of them, and I in particular had 6 in mind that I think are usually advanced. First, and this goes back to the early parts of the first term of the Bush administration, the U.S. has now withdrawn from a couple of treaties in a very public way. One was the anti-ballistic missile treaty between the United States and Russia, and then somewhat later a treaty that you may or may not know about that gave the United Nations Court, the International Court of Justice, sits in the Netherlands, jurisdiction to hear certain disputes that relate to situations in which foreign nationals have been arrested in the United States. The United States withdrew from that treaty a couple years after withdrawing from the anti-ballistic missile treaty. Second, you may remember a great controversy early in Bush's first term about the administration's so-called unsigning of the International Criminal Court Treaty. More in the news lately certainly is a lot of controversy about the decision by the Bush administration not to give protections of the Geneva Conventions, which I'll talk about as to terrorist detainees, such as Guantanamo. There's also the now famous or infamous military preemption doctrine. This, yes, is the question that Sarah Palin was asked in the interview. What is the Bush doctrine? It's the military preemption doctrine that President Bush announced, and I'll say more about that. A very dramatic example that people would, I think, advance would, of course, be the invasion of Iraq in 2003, invasion of another sovereign country. Many people regard that as at odds with fundamental international law principles governing the use of military force. And then finally, and I think the toughest example in some ways to talk about, but I am going to talk about it, is, of course, the alleged authorization of torture in the war on terrorism in violation of a variety of treaties and other international law materials. So a long bill of particulars, and probably one could add to that list, but these are the 6 that I think particularly come out quite a bit. And they certainly give a lot of plausibility to the critique that I described. But nevertheless, in part to be a little bit provocative, but also because I think the critique is a little bit too simplistic, I want to unpack that and suggest that, in fact, it does not give us a fully accurate picture of the Bush administration's relationship to international law, and in some ways it gets the critique exactly wrong. It is off base. I want to go at that in a couple of different ways. One is that critique completely omits some important contributions that I think we have to recognize that the Bush administration has actually made to international law, and they usually are left out of the story. But a more important point from my perspective is the critique omits or neglects a precise assessment of what's going on in many of the examples that are talked about. Almost none of these examples involve direct repudiations by the administration of international law, or even analysis that's advanced that in any way suggests international law is not being treated seriously or as if it were like any other type of law. And I will even suggest that in many of the controversial examples, and I need to obviously give some explanation to defend this, the administration has advanced perfectly respectable legal arguments to support its views. So if one ends up agreeing, you'll find out whether you do in a little while, whether you agree with these complications to the view, I will advance a different sort of lesson than the standard view. And the lesson is that most of the problems with the administration's relationship to international law have not been a result of a disregard for international law, a lack of attention to the legal materials, or a failure in general to treat international law as law. I will concede that there are problems, and I'll describe some of them, but I think in many respects they're the result of the opposite phenomenon than is usually suggested, which is that sometimes the administration has been too legalistic about international law, has focused too much exclusively on legal considerations to the exclusivity of other non-legal considerations that often are even more important to international relations than law. And I'll explain more about that near the end of my talk. So first point, I need to complicate the standard view that international law is not taken seriously in the Bush administration, disregarded whenever perceived to be against U.S. national interest, narrowly conceived. So just a couple of things about contributions to international law. One could do a sort of an empirical assessment and look at some raw numbers here, which I think is the starting point. And you might look at the number of treaties that presidents have entered the United States into. They obviously need to get the Senate's advice and consent, so it's not an easy process sometimes, but it completely depends on presidential initiative. No treaty can be formed by the United States without the president agreeing. And I've looked at the raw numbers, and they're interesting. And I went back through the Clinton administration and then into the Bush administration. And you find that during the Clinton administration, the United States concluded about 275 international agreements per year on average. If you average it out, they go up and down each year, which is typical. The average of the first Bush term per year is a little bit lower. It's about 230 binding international agreements per year. In the second term, the numbers have gone substantially up, and it's now an average of around 300 per year. That is over the average of the Clinton administration, which may be surprising. These are some multilateral, some bilateral treaties, but binding international instruments being concluded by the administration and advanced to the Senate, and the Senate's being persuaded to agree to them. And at least the latest numbers indicate, in fact, we'll have a record number of agreements concluded by the United States through the Bush administration this year. So that's interesting and suggestive that maybe more is going on than just the standard view would suggest. But I also want to more qualitatively point out a few subject areas that we might think about. So one area where I think you have to give some credit to the administration. You have to think there's been a lot of money and emphasis and time spent on this area of international law. And whether you think they've been successful or not, there's going to be a lot of debate about that. There's no question this has been a priority, and a lot of resources have been spent to bolster international law, which is on the issue of nuclear nonproliferation. And there's been a huge amount of State Department resources and monetary resources poured into that. The United States, of course, have been very active under the Bush administration in pushing, both in a very hard way and sometimes in an inducement way, to get countries to comply with the Nuclear Nonproliferation Treaty. And in my view, one of the major successes of the first Bush term, in fact, near the end of the first Bush term, was to get Libya to abandon its nuclear ambitions and give up all of its nuclear materials, which were literally flown out by U.S. government officials out of Libya so that they didn't have these materials. And to get another country in that very belligerent posture that the United States was in with Libya for so long, to do that, I thought was a major foreign policy success and is a signal that this was a high priority, and I think has been. There have been numerous Security Council resolutions which take a very cooperative action by a number of countries that have gone through the Council in recent years with respect to North Korea and Iran, and in general with respect to nuclear nonproliferation, all with the leadership of the administration, and again, getting the cooperation that they sometimes don't get in other areas, but certainly getting it here. The United States started something called a Global Partnership Against the Spread of Weapons and Materials of Mass Destruction. It has committed more than $10 billion in resources to it, a major commitment that's very cooperative and multilateral. Perhaps even less surprising, maybe even than that, the United States has been, under the administration, a leader in developing more international law on counterterrorism and more generally in criminal law enforcement across borders. So after the September 11th attacks, with the leadership of the United States, the Security Council agrees, set up a major new committee, a counterterrorism committee. It's been very active, particularly in trying to restrict financing of terrorist organizations, and has had some significant successes there, and also with ensuring that nations extradite or prosecute terrorists. There have been concerns and issues raised about this terrorism committee in terms of due process and the way in which they make certain kinds of decisions, but there's no question it's a significant contribution to international law on terrorism that require cooperative, multilateral action. The administration was in a leadership position. In addition, right after 9/11 and continued thereafter, the United States persuaded the Council and the UN to recognize that under some circumstances, international law allows for some self-defense against terrorism, something that had never been recognized in international law specifically before, when particularly the terrorists are being harbored by another nation state, as in Afghanistan. On more general law enforcement issues that go just beyond, more than just terrorism, the United States has led the way in developing a number of big treaties in the last few years. There's one on cybercrime, for example, a big addition to the treaties on international crime, and also on more generally organized crime. The United States was a significant player in both of those. They were ratified, and they've gone through the U.S. Senate as well. So those are just a few examples. You can see that it may depend on which subject matter we're talking about. It's dangerous, I think, to overgeneralize about the administration's views of international law and whether it cooperates and whether it commits itself to the enterprise. But that's the first point of my critique, which is there's more going on here, and it's not all moving in one direction. The more important part of the critique of the standard view is that even when we look at the controversial actions by the administrations, the 6 examples that I gave a couple of minutes ago, it's actually more complicated than it first seems. Most of those examples, as I'm about to explain, do not involve a disregard for international law in at least the most obvious sense. They do not involve a situation where international law materials are being ignored or not treated as legal in nature. And in a number of them, and we might have some disagreement about which ones, I will even argue that the administration's arguments are perfectly respectable legal arguments, in some cases even convincing. So the one exception, and maybe and I said the hardest example for me, is the torture example. So I will address that in a couple of minutes. People might have questions about it. So start with some of the easier ones, in my view, in terms of the law. There was a couple of well-publicized U.S. withdrawals from treaties in the Bush administration: anti-ballistic missile treaty, the treaty concerning the rights of foreign nationals who are arrested, and whether the International Court of Justice could hear those disputes. I can sort of address that quickly. International law, it is quite well settled, generally does allow nations to withdraw from a treaty to which they are a party. It is a particularly easy case when the treaty specifically provides for withdrawal, as many treaties do. And it turns out the anti-ballistic missile treaty was one of them. It actually provides that either party may withdraw upon 6 months' notice. Now, this is a treaty that was originally ratified in 1972 between the Soviet Union and the United States during the height of the Cold War, and the Bush administration made the decision that it was outdated, and they gave explanations. You can agree or disagree, but they're at least arguments we can understand. The argument was, we don't have the foreign policy we had in 1972, and nor does Russia, formerly the Soviet Union. That policy was one of mutually assured nuclear destruction. And we depended on not being able to shoot down nuclear missiles that might be coming in order for that deterrence to work. We don't have that as a cornerstone of foreign policy either here or there. We have other foreign policy problems, rogue states who are developing nuclear materials and terrorists who are trying to acquire the same. And in that regime, where the balance of power does not depend on mutually assured destruction, it makes less sense to absolutely forbid the ability to develop technologies to be able to destroy incoming missiles. And in light of that, the United States, under the Bush administration, exercised what was clearly a right in the treaty to decide to withdraw. And in fact, they gave the 6 months' notice as well. Hard to argue that's a violation of international law. Whether you think it's a good idea or not, of course, is a different topic. As there was this other treaty that came up a couple years later about the International Court of Justice, whether they could hear cases involving the United States. They tended to be death penalty cases involving the arrest of foreign nationals. This treaty does actually not say one way or the other whether there's a right of withdrawal, so it's a bit harder of an issue. But summarizing a lot of materials, I can tell you that it has long been the practice of many nations, not just the U.S., to be able to withdraw, sometimes with notice or not, from the jurisdiction of the International Court of Justice, and many nations have exercised that right in the 60 years of the court with very little controversy as a legal matter that nations have that ability. And it seems fair to assume, the treaty doesn't address it one way or the other, that this treaty, which was ratified in the late 60s, took account of that practice and did not intend to bind the United States or any other nation to the court forever without any ability to withdraw. And so there probably was a right of withdrawal. The United States exercised it. There might have been some implied notice requirement, but certainly that period has passed, long past since 2004 when the Secretary of State Rice exercised this withdrawal. It's worth noting as well, just to even complicate the picture a little bit more, the United States did withdraw from this jurisdictional treaty, but the Bush administration, to many people's surprise, actually sought to take kind of extraordinary action to compel state courts in the United States to comply with an earlier judgment of the International Court in a case coming out of Texas, a death penalty case, and in some other cases as well, pending in some other states, and took an unusual step of issuing a memo that was construed as an order to the state courts of the United States to give new hearings in some cases as had been ordered by the International Court of Justice in a ruling the United States did not agree with, but Bush administration was nevertheless sought to comply with by this order. Some of you may know the U.S. Supreme Court last term held in Medellin versus Texas, this order did not survive as a matter of domestic law. That is, that the president did not have this authority to comply with the treaty in this manner. And whatever one may think about what the President Bush's action suggests about his views of executive power, we have different lectures on that topic. I think it's impossible to say that this, by itself at least, is a piece of evidence that the administration was simply disregarding international law when it was trying to, albeit unsuccessfully, force states, usually something it's reluctant to do, to comply with an unpopular decision of an international court. Okay, another example might seem a little bit more controversial, is the so-called unsigning of the International Criminal Court Treaty, something that happened pretty early in Bush's first term. Let me just, part of the answer here is you just have to know more of the facts. And part of the facts is that President Clinton, on December 31st, 2000, was about to leave office, had about 2 more weeks in office. Bush v. Gore had been decided by that point, for better or for worse. And that is when President Clinton signs the treaty on behalf of the United States, knowing that, by the way, the incoming president is quite opposed as a policy matter to this criminal court treaty and U.S. involvement in it. The international rules on this are that signature of such a treaty does not bind a nation to the treaty. One of the reasons for that is that many countries like the U.S. divide the treaty power between their executive and their legislative branch. So the United States in many cases could not bind itself to a treaty without going back to its Senate. And that's true in some other countries as well. Rather, the signature is an indication that at least the executive thinks the negotiations are finished and it may be acceptable to the executive, but there's no promise, actually, that their country will agree when they take it back home. The United States did not become bound by the International Criminal Court Treaty in any strong sense by Clinton's signature. Nonetheless, President Bush, not too long after coming into office, announced and actually had a letter sent to the Secretary General of the United Nations, making clear that the United States did not intend to become a party to the International Criminal Court Treaty. The Bush administration officials did not sneak into the Treaty Depository Office of the UN with a big eraser to try to undo Clinton's signature. There was no unsigning in that sense. There was really just an announcement to make it clear the U.S. was not going to join this particular treaty. There was a lot of controversy about that, but in my view, it all boils down to a policy dispute about whether the United States should or should not have joined this treaty and whether it's in our interest, and that although there's a lot of talk about international law, it's hard to see where that goes. There's a big treaty that governs when you can withdraw from treaties and what your signature means, and it says that you might have some modest obligations once you sign a treaty, and then I'll read you the rest, until the country shall have made its intention clear not to become a party to the treaty. That's when your obligations end under well-settled international law. It's hard to imagine a better way of giving notice than to send a clear letter to the Secretary General who runs the Treaty Depository of the UN, making it clear to all the other parties what your intentions are so that they're not confused. Again, one could easily have a big policy dispute about what the Bush administration did. Over 100 nations have now joined the International Criminal Court Treaty. They see it quite differently, and there may be good arguments the United States should have had a different policy view, but very little argument, in my view, that the United States was showing contempt or disregard for international law. In fact, followed the international law process for giving notice more to the letter than any country had done before. Again, a further complication is the United States has not, even under the Bush administration, been radically opposed in all instances to international criminal courts or adjudications. The United States is a significant funder and supporter of the ad hoc criminal tribunals for Yugoslavia and Rwanda, including under the Bush administration, the Special Hybrid Court for Sierra Leone, and the Bush administration has even acquiesced in uses of the International Criminal Court that it didn't support originally, like the referral of the Darfur genocide case. So far, I think so good. In terms of international law, I think has not been indicted significantly by those examples. Now, it gets harder, I'll say, as we get into the next couple of examples. And the next one is the Geneva Conventions. There is continuing controversy about this. The decision by the Bush administration, as it had this detention policy, capturing and detaining people from Afghanistan, but also other places, not to accord them the protections of the Geneva Conventions. By the way, put aside Iraq for a minute, where the policy was to give protections of the Geneva Conventions, interestingly, and I'll come back to that in a second. So what are the Geneva Conventions, in case anybody doesn't really know much about them? There are 4 treaties that were established after World War II, negotiated very much with World War II abuses in mind. And the one treaty that's particularly relevant is the third one. It's about the prisoners of war, the Geneva Conventions relating to prisoners of war. And the Bush administration's position was that it was detaining people, particularly at Guantanamo in Afghanistan, and that nevertheless, that if you look closely, as a matter of international law, they were not entitled to the protections of prisoners of war. Part of their argument, I think, is quite solid and quite convincing, which is that as to the conflict between the United States and al-Qaeda, which is certainly a big component of the war on terror, you can just look facially, and the Geneva Convention does not apply. And why is that? In its first clauses, the Geneva Convention only applies to armed conflicts between high contracting parties. Well, there's no question al-Qaeda is not a party. It could not, in fact, become a party, nor would it want to be a party, since it obviously does not comply with the provisions that would be required anyway. This is not a conflict in that sense that's covered by the Geneva Conventions. Maybe it should be covered by other bodies of law, but not that. And I think that's a very easy and solid argument as to the conflict with al-Qaeda. Now, this conflict is more complicated than just that because, of course, it starts and still involves, today, a conflict with what were once the main armed forces of Afghanistan, or at least much of Afghanistan, which is the Taliban. And the complication is that Afghanistan as a country is a party to the Geneva Conventions, and so one can talk about the Taliban conflict with the U.S., at least, as in some sense a conflict covered by the Geneva Conventions. Nevertheless, the Bush administration's position was, with the Bush administration, just to be very precise, its position ultimately was, yes, that's right. This is a conflict that gets over the first clauses of the Third Geneva Convention. I think that surprises people. The usual description in the press is they simply said no Geneva Convention applicability at all, and that's not correct. Bush made the decision that, in fact, because Afghanistan's a party, that in theory the Geneva Convention may be triggered. But many of the provisions of Geneva are about special protections for prisoners of war, and the Bush administration made the decision that the Taliban did not qualify for those protections, even though Afghanistan's a party. Why? Well, their argument is that to qualify, you have to wear uniforms, distinguish yourself from civilians. That's a fundamental part of the laws of war. You have to have a good enough command structure, and perhaps most importantly, you actually have to, as a general matter, comply with the standards of the laws of war. And in their view, the Taliban met none of those requirements. Now, this is a complicated legal argument. I don't think the administration has anything like a slam dunk prevailing argument on this particular point about whether those requirements apply here. And the reason is the Geneva Convention can easily be read to say that as long as you're a member of the regular armed forces of a high contracting party, you don't have to meet any other requirements. And if that were true, once we agree that Afghanistan's a party and this is the really ruling armed forces, we might not have to get into these other issues about uniforms and the like. And indeed, I would say the plain language of the Geneva Convention supports that view against the Bush administration. On the other hand, prior treaties that the Geneva Convention built upon and general international law before that did assume that one, to qualify as a prisoner of war, one did have to follow these other standards, and earlier treaties made that quite explicit. And it is arguable that the phrase armed forces of a party assumes the backdrop of that prior international law, and certainly nothing in Geneva expressly says otherwise. So there's at least a plausible argument here, if not more than that. And commentators are divided on the question. None of this is to say this was a wise decision by the Bush administration to avoid even prisoners of war protections for the Taliban. It's very controversial. And I'll get back to this in a few minutes. It may have been much wiser to, without conceding the law, to nevertheless voluntarily apply more than technically might be thought to be required. The U.S. has done this before in the Vietnam War. The U.S. had good arguments for not giving Geneva protections to irregular Viet Cong fighters, but nevertheless decided to do so. And I'll in fact suggest in a couple minutes the administration should have thought harder about this. Another thing to keep in mind, though, about this Geneva example, even if you think at some points in particular they're not persuading you, even if the Geneva Conventions are fully applicable, they don't in any way indict the detention policies of the Bush administration. They allow fully for detention of people in an armed conflict, and the Supreme Court has allowed the administration, in fact, under that authority to detain. It would raise some questions about some interrogation policies, military trials, but not the bigger picture, which is whether we can have Guantanamo and the like. So Geneva is also not fully an indictment of those practices. There are more complications about Geneva, but I'm not going to run through all of them right now, other than to say, and if any people have questions about them, I'm happy to engage on them, is that on each of the other points that come up, there's something about Common Article 3, which I'm not going to go through right now, and something about individualized hearings on the Geneva Conventions, where I think in both instances the administration adopted a controversial positions, but one that would certainly, if it were in a court, survive Rule 11. These are not frivolous legal argumentations. Particularly on Common Article 3, they ultimately lost in the Supreme Court on this provision. This is a provision that says certain minimum requirements should be given, even for people who are not a high contracting party. But it says only in conflicts not of an international character. And the administration, I thought, had a quite good argument, particularly if you look at the legislative history and the Red Cross commentary. That's all about internal civil wars, and it doesn't really address international conflicts of a geographic sense. And the Supreme Court in the Hamdan case disagreed with that and thought international meant only conflicts that are between nations, and therefore the conflict with al-Qaeda is not of an international character, and therefore these minimum protections do apply. I think as a policy matter, the Supreme Court's opinion is great. They were looking for some law. They found a way to get there. But the administration's position was certainly reasonable as a construction of the text of the Geneva Conventions. Again, of course, there's a separate debate here about the policy wisdom, and it is worth noting that there was a big conflict in the executive branch over the policy wisdom of deciding not to give individualized hearings and not to give any Geneva protections. These documents all leaked out later for our edification. We know that John Yoo and others in the Office of Legal Counsel and the Justice Department made very broad claims about the Geneva Conventions, including the argument that they don't apply to Afghanistan because it's a, quote, failed state, a theory that nobody had ever really advanced before in international law about treaties. And the State Department pushed back very heavily. The legal advisor, Will Taft, sent back a very long response saying that, among other things, that we ought to go further than what we think the law might require, it would be in our interest to do that and try to persuade the Office of Legal Counsel that this was the better policy view. And in addition to a long memo, the Will Taft, the legal advisor, sends this memo back to John Yoo, and it says, "Your position is at this point erroneous in its substance and untenable in practice. Your conclusions are as wrong as they are incomplete. Let's talk." And I love that last part. There was a tense relationship going on within the executive branch between the part of the government that's very focused on international law and the part that tends not to be, which is more in the Justice Department. The key point is a couple things. One is that Bush did not accept the strong John Yoo arguments about failed states. The State Department pushing back actually mattered, and they backed away from that position. And second, that on the other issues, there are at least reasonable, if not better, arguments as a matter of law, and that the dispute, even the one between Taft and Yoo, is very much about a policy issue. And my own view is the State Department had the better view, but it's not so much about international law per se. Okay, a couple of other, getting to the most controversial examples now. What about the Bush Doctrine, the preemption doctrine? This was announced in 2002 that there is this military right to preempt states that are developing weapons of mass destruction. Many people think this violates international law on the use of force. The UN Charter, which is a very big treaty on the use of force and other issues, talks about self-defense, but only in response to an actual armed attack, it seems like. And obviously, if you can preempt, you're not waiting for the armed attack. And so many people think it violates international law. It turns out the argument is much harder than that. And even the UN Charter, when it talks about self-defense, actually talks about nothing in the Charter shall impair the inherent right of self-defense. It seems to recognize some pre-existing right that's actually not actually regulated by the Charter. And one would have to look to history to think more about what that inherent right is. And it turns out, historically, there is a lot of support for some kind of anticipatory or preemptive right of self-defense. You don't always have to wait to be attacked. Now, there's a lot of debate about how far that would go, of course. Interestingly, if you look at the big strategic paper that Bush issued on this point, it is very focused on the pre-existing international law and trying to make an argument that that international law supports this new direction. It may or may not be persuaded by it, but it very fully engages with international law and does not run away from it. I'll just read you a paragraph or so. For centuries, international law recognized that nations need not suffer an attack before they can lawfully take action to defend themselves against forces that present an imminent danger of attack. Legal scholars and international jurists often condition the legitimacy of presumption on the existence of an imminent threat, which is right, most often a visible mobilization of armies, navies, and their forces preparing to attack. We must adapt the concept of imminent threat to the capabilities and objectives of today's adversaries. Rogue states and terrorists do not seek to attack us using conventional means. They know such attacks would fail. Instead, they rely on acts of terror and potentially the use of weapons of mass destruction, weapons that can be easily concealed, delivered covertly, and used without warning. Now, you may or may not be persuaded by that, but you can see the argument, which is the idea of imminent threat, which is in international law, needs to take account of modern weaponry and conditions, and there's an argument that that would allow for more preemption. Again, even if you're not convinced, there's clearly an engagement here and an argument that quite directly worked with international law. The Iraq War has a lot of complications I won't go through unless you have questions. Fortunately, you might be thinking preemption there, and fortunately, the Bush administration, for the administration, did not make, although you may think they did, a big preemption argument for Iraq. This was not the legal argument for Iraq. If it did, it would be quite weak, as we know in hindsight, since nobody found weapons of mass destruction in Iraq. And if that was the argument, it might cause us all sorts of reasons to be suspicious about preemption. That was actually not the legal argument. The argument was the Security Council, which can authorize warfare, had authorized warfare against Iraq back in the first Gulf War, which they did, and that's perfectly lawful. And they conditioned the end of that authorization with a ceasefire resolution in 1991. That ceasefire resolution was conditioned on Iraq's continuing compliance with inspections regimes, destructions of certain kinds of weapons, reporting requirements, having the no-fly zones and some other requirements. And there's no dispute that for the next 10 years or so, Iraq repeatedly violated all the terms of the conditional stoppage of the usage of force. And indeed, many times during that period under the Clinton administration, the U.S. used force against Iraq with little complaint by the UN, including bombing strikes to attack their facilities when they would violate the no-fly zones. It got so bad in 1998, they didn't cooperate with the weapons inspectors. The inspectors finally just had to leave. And this was under the Clinton administration. U.S. and Great Britain then did a 3-day bombing campaign against Iraq with little complaint in terms of the international community. It was thought there were breaches of the Security Council resolutions, and this immunity from the use of force that Iraq had was conditional. That takes us up to 2002. And by the way, there was a lot of tensions, as you may remember, over whether they're complying with the weapons inspectors have gone back in. They're not cooperating pretty clearly. A lot of disputes about their unwillingness to turn over records. Finally, Congress gets so upset about it as well, they authorized President Bush to go to war if, in fact, the cooperation is not forthcoming. It's a month later that the Security Council, after much negotiation, issues a resolution saying Iraq is still in material breach of its obligations, is be given a final opportunity to comply, and if it doesn't, it will face serious consequences. And the Security Council does so knowing full well that Congress of the United States has already conditionally authorized a war. This is not to say that this is legal, but there is a substantial argument that under the Security Council resolutions in force, there was some authorization to use force, particularly if you believe that Iraq still had problems with cooperation after November 2002. My own view, by the way, is that, in fact, I think the Bush administration's argument does not persuade me, and for a lot of complicated reasons I'm not describing. But my point is simply there are some serious legal issues here. Okay, the hardest issue for me, and maybe for everybody in a sense, for policy and other reasons, is torture. And I said I would get to this. I don't want to shy away from the hardest examples for my case. The United States is certainly a party to a very important treaty that bans the use of torture. And torture may violate other international materials as well. And as you probably know, these got leaked out too, the Office of Legal Counsel very infamously adopted in August of 2002 a very narrow definition of what torture would mean in this context of the treaties. They said that in order for something to constitute torture, if you're talking about physical pain, it has to be equivalent in intensity to the pain accompanying serious physical injury, such as organ failure, impairment of bodily functions, or even death. Okay? That's a pretty high standard and would leave out a lot of interrogation practices that are short of that from being considered torture. The other prong of the torture treaty says sometimes things that cause mental harm can be torture, and the OLC said if that's the case, it must result in significant psychological harm of significant duration. So things that are just immediately very, very distressful would, again, be exempted from being torture. When this memo was leaked out, it was hugely controversial on all sorts of fronts. And I will say, to sort of summarize a lot of thinking I've done about it, the memo does contain bad legal reasoning. Among other things, it does not take adequate account, since it is an international treaty, of the views of the terms of the treaty of other parties to the treaty. And indeed, most other parties would not agree with the OLC's views. And that's important when you're talking about a multilateral document that is negotiated with other countries. Nevertheless, my point about this is going to be that although certainly I think the existence of this memo may tell us or signify a lot about the culture of the Office of Legal Counsel in the period, and maybe even some other issues about the Bush administration's relationship to executive power, I think it does not tell us a lot about the relationship to international law. Why? First of all, there's some sui generis aspects to this memo and this event. Unlike all other controversial examples I've given, and more that you could probably throw out, this is the one example that did not involve any participation by the international law component of the executive branch, which is the State Department. They were not involved at all. There was no opportunity for dialogue for them to advance all the materials they're experts about, which is the views of the other parties. Second, there's a lot of stuff in the memo about how President Bush could, if he wanted to, authorize torture. He never wants to invoke that right, he says, and he never does formally, in any setting, covert or overt. He never makes an overt attempt to override the Torture Convention or international law. Now, my point there is simply that attempting to read a prohibition in law narrowly is distinct, even if quite problematic, from simply disregarding the prohibition altogether. A third point, to distinguish it from other things going on in the administration, is that the administration, unlike every other major controversial example, backed away from this one completely. And indeed withdrew the Office of Legal Counsel memo 2 years later, within a year of it being discovered, and replaced it with a much more narrow and much less controversial memo with reasoning about the Torture Convention that takes a broader notion of what constitutes torture, much closer to the views of the other treaty parties. So in that sense, it's hard to generalize to a lot of other examples, but they did not change course. Now, you may be thinking, as I would be thinking, what about the actual practice? What has the Bush administration really done behind the scenes in addition to this memo? We don't know fully, of course. But a couple points just to get the record a little bit clearer than sometimes it is in the press. The administration, you know all about Abu Ghraib, very embarrassing, problematic event during the Bush administration, has nothing directly to do with this topic. Why? The administration not only applied the Torture Convention in Iraq, it applied the Geneva Conventions, which bar any coercive interrogation of detainees. Now, there may have been lapses in command and all sorts of problems with the kind of messages that were being sent, but they are not about a decision to disregard international law in Iraq. And indeed, you know that some people were actually prosecuted for violating both the federal statutory law and the Geneva Convention provisions in Iraq. And you may be thinking, what about Guantanamo? The administration never authorized anything probably close to torture in Guantanamo, interestingly enough, although it's sometimes suggested that they did. The list is out. We've discovered those documents as well. And the most aggressive interrogation techniques for Guantanamo were things like isolation and change of sleep patterns, okay, which may or may not, probably would not be acceptable in Geneva. Remember, there's a big debate about whether Geneva applies there, but are not torture under any reasonable definition. So where does the flack come from? Where did the administration authorize torture? They may have. And what we're talking about is about a dozen detainees held by the CIA, not at Guantanamo for a while. And it looks like, from the little bit of information that we have, they were authorized to have so-called enhanced interrogation techniques. Some of them you may not think are torture, although they may be quite coercive, a light and noise bombardment, forced standing for long periods, etc. But for maybe 3 of the detainees, and of course I don't know, I'm not privy to all the information, but this is what the press suggests. For 3 of the detainees, waterboarding was authorized. And I think one can reasonably conclude that waterboarding is torture. There could be debate about that. And of course the CIA might respond, by the way, that under that bad OLC memo, they were perfectly comfortable thinking that it was not torture, since it didn't involve sustained psychological injury or pain on the level of organ failure or something like that. It's not a great memo, but one the CIA had in place at the time, and certainly it didn't write it itself. Nevertheless, I think we conclude that it could well be the case that the Bush administration, through its authorization to the CIA, particularly for the 3 detainees, violated the Torture Convention. I'm comfortable conceding that. But my point would simply be, I don't know how much we can generalize from that fact. How much can you generalize any time, particularly when there's big national security issues in the balance, that an administration decides to have some kind of a breach of international law? No president of which I'm aware has gone through any long term in office without violating international law. And just to give you one of really countless examples, I think it's very clear that the Clinton administration violated international law in conducting the 70 or so day bombing campaign in Kosovo in former Yugoslavia. And we don't generalize from that to say that all of the 2 terms of the Clinton administration showed an antithetical relationship to international law. So bottom line, and then I'm going to talk about a couple of lessons. Bottom line is, despite, I think, some overgeneralizations, maybe even caricatures of the Bush administration, I don't think it's accurate to say they've simply ignored international law or failed to treat it as law. Indeed, I think they've made some important contributions, both numerically and substantive, to international law. And in many of the controversial examples, the debate is about policy, but in terms of the law, they at least had respectable legal arguments, and sometimes better than that. None of this, and this gets to the lessons part, none of this is to applaud the administration's approach to international relations, and I want to distinguish that point. I, in fact, think there have been significant problems with the approach to international relations, particularly in the first term of the Bush administration, much less so in the second term. And I want to suggest, just to be a little bit contrarian, that in fact part of the problem is that they've been too focused sometimes on international law and law in general. So one of the lessons, it seems to me, the Bush administration is the importance of international law is not solely or even often chiefly in technical legal argumentation, the best reading of the language. In fact, it's often intertwined very significantly with issues of credibility, engagement, persuasion, and considerations that some international relations scholars have talked about as fundamental to exercising something called soft power. This soft power idea is the idea that in some instances you can get other nations to support your foreign policy without resort to hard power, that is economic sanctions or military pressure and the like. And this does not always work, of course. You can try a lot of soft power, and if that's all you do with North Korea, you may not get very far. But when it does work, it's a much cheaper way of having foreign policy success than hard power. Even when you have to use hard power, It can make it much less costly if you also have a lot of international support and soft power behind it. And I think that's painfully illustrated by a comparison of the first Gulf War with the Iraq War. It is also generally helpful in diplomacy, of course, to have it backed up by some hard power as well. And I don't want to put that aside. I think that does help. But it also requires, I think, patience, often understatement, and a willingness to engage and listen in order to have diplomacy work. And I think those qualities, particularly in the first term of the Bush administration, were in short supply, not particularly related to international law, but certainly related to relations. In fact, I think the first term of the Bush administration purposely gave the impression to other countries, including allies, that they did not feel the need to listen to others or explain themselves on their views, lashing out at allies even, like when Rumsfeld made the remark about France and Germany, they're just old Europe, we don't need to listen to them. David Addington, who is famous Duke grad, Vice President Cheney's counsel, often apparently remarked in meetings that, well, the foreign governments, including the allies, don't have a vote in our decision-making. True, technically true, but there's a certain attitude there that obviously may not be conducive to diplomacy. The appointment of John Bolton as ambassador to the UN, a recess appointment, despite the fact that he was the most prominent and notorious critic, practically, of the UN and other institutions, again, symbolically is a way of undermining your soft power. Even if the administration was right to pull out of the treaty on the International Criminal Court, it did a lot more than that. It repeatedly criticized the court and attacked it and sought to undermine it by pressuring other nations either not to join or to enter into treaties that might be inconsistent with it. Geneva Conventions, they had the sometimes good legal arguments or reasonable ones, but they never took account of other things, like the symbolic value of the conventions. I think they neglected an opportunity to voluntarily adopt more protections and claim a position of moral leadership on the conventions as opposed to just a technical legal position. And more generally, of course, the Geneva Conventions illustrate how often the lawyers for the administration were very astute and quick to find no law applicable to the administration's actions. And as a matter of legal analysis, I think often they were persuasive or at least reasonable. But the problem is that left the administration literally operating without law at all. And in that kind of outcome, it can be quite unpersuasive, both to allies, and certainly we found out, the administration found out to its dismay, to American courts, who were not comfortable with that kind of outcome, even if you show that as a logical matter, they're right about the language of the treaties. And I think good lawyers, let alone good policymakers, should have foreseen that as not a pragmatically acceptable place to come out of the legal analysis. Now, I do want to say, just to end, a couple of somewhat more complimentary things. I think the administration's first term and second term are different, particularly the last couple of years, probably a lot of reasons for that. And I think the approach to international relations in the last couple of years has been much better. The current legal advisor, John Bellinger, who came to Duke a year or two ago to speak about some of these issues, has gone out of his way on behalf of the State Department, travel the world, make many speeches, very difficult speeches sometimes, about U.S. detention policy, U.S. views about the Geneva Conventions, U.S. views about torture, and sometimes for very hostile audiences, and has tried to engage with the allies and others who might be critical, and at least show that the United States is listening, show that we're going to take the time to explain our views if we do think they're right, and certainly send a different kind of message than I think the first term did. Even Bellinger, a year and a half ago, went to the UN Committee on Torture to have a long grilling session about U.S. practices there. I thought a brave move to make, but I think a good one. Also, just generally, we've seen, as I said, an increase in the number of treaties in the second term, much more receptivity to dialogue even with adversaries, to some extent, even with North Korea and Iran, big change from the axis of evil speech. And the last thing about that I'll say is, in emphasizing the problem here, I think, is in international relations and the process of international relations and the message that tone might send. At least I don't want to suggest that the United States should in any way concede away fundamental interests or values just to make other countries happy. And my view is the president certainly should not do that, and I think won't do that. So for anybody in the room who thinks that automatically President Obama is going to have radically different substantive positions on foreign policy, my prediction is you will be disappointed by that. But, as I've just said, I think process and tone and dialogue matter significantly as well as substance. And my guess is that we will see a change in that regard, although a change that has already been started in the second term of the Bush administration. So, in short, I think there are lessons to be learned from the relationship of the Bush administration to international law, but they're much more complicated than the conventional story of a simple disregard for international law as law. And there's some positive lessons that will come out of that. Thank you.
Thank you very much, Kurt. We have 10 more minutes, and folks have questions. We'd be very happy to entertain them now. Okay, Sonia?
I'm wondering if you could speak a little bit about the importance of honesty in international law, in the sense that in international law, unlike in domestic law, there are fewer courts that you can go to get enforceable judgments and things like that, so it depends much more upon relationships between treaty partners, which in some sense depends a lot on the honesty of the treaty partners. For example, when President Clinton ordered the military debombing in Kosovo, it was not a secret. Yet the CIA prisons and the policies at issue there, the legal interpretations, were a secret and would have stayed a secret if not for some diligence in the press.
Yeah, good question. And I think I agree with the thrust of the question, which is that a big part of the concern one ought to have in terms of the use of the soft power, in addition to your substantive positions, is credibility. And credibility, I think, very much depends on, first of all, getting your facts. If you're going to make assertions, having them be reliable. And we know, of course, for example, the assertions about what we knew about Iraq were not very well backed up and turned out not to be verifiable after the fact. And that's going to undermine, and I was in the government for a year while the Iraq war was ongoing, and I can just tell you from experience that losing credibility on that issue, even though it logically didn't have to affect other issues, did affect other issues. So when the United States went to go to the Security Council right after the Iraq War to get some more resolutions on terrorism, it was a much harder time having countries trust assertions of the Bush administration representatives. So there is a lesson just from candor and in terms of making assertions. Now, the other part of it is conducting things kind of out in the open where there can be public debate. I think that's part of it. Now, some things the administration did that are controversial. Probably most of the examples are still pretty open. They're just very controversial. So whether it be the ICC treaty or war in Afghanistan or the war in Iraq, those are somewhat quite open phenomena. Some of the things in the war on terrorism are not true. And one of the problems is a tension here, because some things you probably have to keep classified or secret in order for them to be effective. Surveillance is a classic example. How much are you really going to talk about your surveillance policy if it's going to be effective? But it does, if you have to keep things secret, it does undermine your ability to do one major thing I described, which is actually engage your audiences about your views and try to persuade people. Because if you're not actually talking about it, you're not persuading anybody, and then you have to play catch-up when things come to light. And it is an inherent problem with secrecy. I completely agree. But I think my point would simply be when it is public, when things are known, it is often much better to engage with the critics than simply say they don't have a vote, which is what often the first term people were saying.
Yes.
In your discussion, you set up a pretty clear partition between international law and international relations. And I was wondering if you could speak to the relationship between them, because in my mind, the U.S. has always been seen, the images as the standard bearer of international law. And after World War II, coming together to lead the world into these great treaties and set up these institutions. And the very act of having to nuance our engagement with international law by even asking the question, is waterboarding torture, has nuanced our convictions in the minds of most of the world. Yeah. And so, and I think that plays a lot into soft power. So if you could speak to that.
It's a good question. I think a lot of people would sympathize with the question. And to restate your question a little bit, you might say that the United States has changed its sort of fundamental position on international law in this sense, which is that for some period of time, you might describe the United States, say in the immediate post-World War II period, as just being kind of an almost uniformly enthusiastic champion of new institutions, new international law, and if anything, trying to be progressive and aggressive about the content of it. And now we see a tone in which it's not, seems to be the opposite. Not to say there aren't reasonable legal arguments, but they're being more loyally about it. They're being more restrictive about how they go about their interpretations. They could have adopted a broader one, but they don't. Part of my response to that is I think it's still it's an overgeneralization about the United States in some ways, although that is something you hear a lot of. To some extent, it almost assumes that more international law would tend to be a progressive development, for example, which I'm just not persuaded that is actually the case. A lot of things have happened in international law since the beginning of the UN, some of which may or may not be progressive. People have differing views. The fact that, just take a random example from a couple years ago when I was in the government, the fact that the International Court of Justice took jurisdiction over a case involving Israel when it had no consent at all from Israel to hear that case, to hear this Palestinian barrier case, controversial, and Israel doesn't show up, and there are concerns, I think, in the United States that certainly the U.S. will be next, and that the whole idea of international law being consent-based is going to start eroding. There'd be good reasons, perhaps, for the United States to say we've been progressive about some other things, but we're worried about how it's evolving over here. If you think some international institutions are political, and by the way, they are, the International Court of Justice, a very beautiful building. I've been there. I taught a course over in The Hague. But it's a pretty political court, even as compared to our, sometimes we talk about our Supreme Court being political, not nearly like the more you learn about the International Court, because they're really in some ways representatives of each country. They're not completely independent. And that has become more true over time. The UN has become more politicized in certain ways, adverse to U.S. interests, than from 1945. It started actually in the early 70s when the United States realized it gets outvoted consistently in the UN General Assembly, first on the China question and then many other questions, because a lot of new countries had come in, very different perspectives in the U.S. The U.S. had only one vote in the UN General Assembly. So our interests can be affected by changes in international law, which shouldn't surprise us, therefore, that the general tone might change as well. But having said that, I don't think there's also anything new about this administration making legal arguments. There were legal arguments in Kosovo or anything else about why it complied with international law, and they had to make certain kinds of legal moves to get there. And finally, the administration hasn't been in all in one direction. It's hard to think of a nation more aggressive in terms of championing broad constructions of the nuclear non-proliferation treaty regimes than the U.S. and some others. And so I think interests always matter, and that was true early on when the U.S. thought in 1945 that its interests were progressing a certain way to prevent another world war, and its interests and international law have both changed. And so I would hesitate to generalize too much. And this is my prediction, is that the Obama administration on many issues is not going to have a radically different perspective on the substance of this. Now, maybe we'll eventually join the International Criminal Court, but I don't know that, and it may not be very quick because there are some policy issues there. We're already wondering what to do about Guantanamo. Even McCain said that he was going to close it, but how do you do it? And even Bush has wanted to close it. So when you come to the actual issues, I think sometimes you find that it's harder than we might have thought.
Yeah. Thank you. I just wonder whether or not we're really looking at this through a useful frame. It seems to me like the discussion that we're having right now is whether or not the Bush administration has utterly disregarded international law in many cases. And as we all know, I mean, there's really only one person in the course of the 20th century who explicitly took that position. He was a pretty bad guy. I wonder to what extent the question should not be whether international law imposes a legal obligation not just to go through the mechanisms of obeying one's treaty obligations and so forth, but to try to comply in good faith. And good faith compliance might rule out making the kinds of arguments that you were just saying are sort of questionable on the Security Council resolutions, for instance, or on applying the Geneva Conventions to prisoners taken from Afghanistan. And then another issue, if I could also address this, is just whether or not complying with the method of withdrawing from a treaty really shows adherence to international law versus the dissolution of a state's obligation under that treaty in the first place. I mean, is it not fair to say that dissolving one's treaty obligations, whether or not you do it by the right protocol, is actually evidence of contempt for international law?
Yeah. I would certainly say no to that last part of the question, but you had, I think, a much stronger point to begin with, and it sort of ties into the previous question as well, which is even if I think for most of the examples, again, I think the torture issue is fairly sui generis and pretty hard, but issues about not joining the International Criminal Court Treaty, issues about withdrawing from a couple of treaties, even the Geneva Convention issues, I think, some parts of those arguments I think are very strong. Some are maybe not entirely persuasive, but certainly within the realm of what lawyers can do. And you would ask the follow-up question, well, should we not only be doing what's within the realm of good, reasonable legal argumentation, should we be more progressively following international law and embracing it in a kind of a good faith way? And part of your judgment about that, of course, I think very much depends on the substance of the international law. Why should it be the case that just attaching a couple words to something makes it kind of presumptively something we should embrace as expansively as possible? Just if I add the words international law to something. What if there was a new treaty, and by the way, Europe might be happy to develop one that substantially restricts the right to abortion? Okay, rights to abortion are lower in Europe than the United States, or substantially restricts the right to speech. Okay, speech rights are lower in Europe. If there were such a treaty, the argument would be, well, if we're going to be in good faith, we should embrace that. tradition that's being developed in it. But why would we want to do that if we think it's wrong, or if it's not even in our fundamental long-term interest? And the answer is we shouldn't embrace it. And fortunately, international law is not violated even in a good faith realm by making consensual decisions about what international law is appropriate and what isn't. And that's why I think on the last point, international law itself says you can be acting in complete good faith as long as you go through the notice requirements and the like that have been built in. And indeed, that's what gives international law some of its legitimacy. If you didn't have this kind of consent basis in international law, there'd be very big questions we ought to raise about who's making it and who's binding the rest of us. We don't actually vote on that international law in any direct sense like we vote for representatives in Congress. Real questions, which are often being raised in Europe about EU law, which is how democratic is it? What are the processes? Most of us don't even know how it's developed. And the more you say that should, as a matter of good faith, be binding even without regard to these decisions, the more I think you'd have real questions about the democratic process.
Thank you. Thank you very much.